Hello, welcome to the Shapiro Law Firm Presents, a Facebook Live event. Today's topic is immigration options for abused spouses and children of U.S. citizens and permanent residents. We're going to give people a couple of minutes to join us right now. While we do that, first tell you a little bit about myself. My name is Amanda Shaffer. I'm an attorney at the Shapiro Law Firm. I primarily practice immigration and family law. And today we're going to talk a lot about something called VAWA, which stands for Violence Against Women Act. It is a piece of federal legislation that it covers many different topics, not just immigration, but we're going to focus on immigration today. And I really like doing VAWA cases. I find that VAWA, along with asylum, is the most rewarding part of my job. And the reason is that when someone comes in to do a VAWA case, they're usually in a bad place. They're scared, they don't have a lot of hope, and as I work with them, I see their confidence build, and when they finally get their green card, just like when someone's finally granted asylum, it's life-changing. So I really enjoy being able to help people in that way, and I think it's really important, especially in light of what's going on right now with the pandemic. People are at home, domestic violence rates have gone up. Give people a couple more minutes to join. I also need to put forth a disclaimer that anything I say here today, any questions I answer, do not form an attorney-client relationship. I am, of course, available for hire. You can contact me after the live event. I'll be happy to help. This is meant for general information and to happy to answer questions, but it does not form an attorney-client relationship. So as people are joining, we'll get started a little bit. This is our second Facebook Live event. In our first one, we talked about legal options for domestic violence victims. And the first thing we talked about then was what the definition of abuse is under the law. And I want to touch on that again because that's relevant for this topic as well. And if you saw on our event page, I put out a poll and I called it Spot the Red Flag. And what I mean by spot the red flag is a red flag is a warning sign. And a lot of people are unaware that they're even victims of abuse. It's part of the reason is because they don't even know what to look for. What people think it has to be physical. Oh, it's not just physical. So the first step in being able to help yourself is recognizing you need the help in the first place. So I put out this poll to see if people could spot what is abuse and what's not abuse. And the answer is it was all of the above, and I'll explain. And someone even added an option, and I thank the person for adding one. The one that was added was that basically the spouse keeps the house dirty all the time, and so when she comes home from work, she's always cleaning. She doesn't get to relax. And usually in certain contexts, that can certainly be abuse. It's more likely to be part of a bigger pattern of abuse, but essentially, the spouse is putting you in a situation where they know that you are tired after work, maybe your spouse doesn't work at all, and they're just giving you a hard time. So that definitely could be one. Some of the other ones, spouse calling you names. Some of these are obvious. They're saying someone's stupid, ugly. I mean, when you're in love with someone, when you're married to someone, you should never be talking down to them, never be demeaning. That certainly can be it. A spouse threatening to have you deported or to call the police on you for saying that you committed a crime when you did it. 100% that can be abuse. Unfortunately, we see stuff like that a lot. A spouse threatening to hurt him or herself. Again, not every single time is that going to be abuse. You have to look at the context. If your spouse is really super depressed and like they say, I want to kill myself, and it's because they see no way out of it, that's one thing. But if they're doing it to mess with your head, that could possibly be abuse. Spouse trying to kick your dog. Animal abuse, child abuse, certainly is considered abuse. Extortion is the next one. The spouse demanding that you give them $1,000, or they're going to call the police. I mentioned before about calling the police, but we see a lot of times what happens is the spouse will come and say, give me money, or I'm going to do X, Y, and Z. That is bad for you. Again, that falls under the abuse category. Your spouse regularly tells you what to wear. You may have a relationship where you're not good at fashion and your spouse is, and he or she dresses you every day, and great. That's not abuse. Again, we have to look at the larger picture here. And keep that in mind when we get into talking about VAWA in a second, about the types of evidence that we have to show and what we write in our statement. It's a picture of the entire relationship, not just one little thing. And then the last option, your spouse shows up to your job unannounced to check on you. If you haven't picked up your phone for 3 days and your spouse can't find you, your spouse showing up at your job might not be abuse. But if it's more like a stalking scenario where your spouse knows exactly where you are and what you're doing and that you're safe, but yet is always following you around, then that can be part of the bigger picture of abuse. So the main thing I wanted to get across with the spot the red flag is that abuse does not always take one form. It can be many different things. We have to look at the larger picture of what we're dealing with when we're dealing with abuse in a relationship. It does not have to be physical. I did have a question from somebody. They asked, is mental torture abuse? Certainly, yes. Physical, mental, psychological, emotional, all of those things. You do not in any way, shape, or form have to be physically abused to be a victim of domestic violence. And if you're just joining us, feel free to ask any questions. If you would like to ask questions anonymously, I have my email open. You can email me, amanda@theshapirolawyers.com, or send me a Facebook message. Or if you want to just ask in the live session, please go ahead. I'm happy to answer any questions. So, we talked about abuse being many different things. And in my experience dealing with VAWA cases, we see abuse peak in a relationship at certain points. And this is important because of the nature of what we're dealing with. When you're dealing with somebody who is a citizen or a permanent resident and somebody who is not, you have a certain power dynamic. And what that power dynamic is you have a person who is essentially in control, this U.S. citizen or permanent resident, and if they want to abuse that position of power, they can easily do it. And that's where we see things like, I'm going to call the police on you, I'm going to get you deported type of thing. And we often see that there are certain points in the relationship where the abuser, that things change. So the abuser everything's great in the relationship. Everybody's happy. And then all of a sudden, things turn south. And we see this at certain key points. So sometimes it's after the engagement. Sometimes it's after the wedding. Sometimes after the filing for the green card. Sometimes it's when you get your work permit. And sometimes when you get your interview notice for your green card. Sometimes it's after you get the green card. And the reason it happens at these stages is because the spouse, who is the citizen or permanent resident, believes that they're losing control. If you have a work permit, you can go work, make your own money, and now you're financially independent. You don't have to depend on this person. They're going to lose you. They might think that you're using them just to get a green card now, and they start to get paranoid. So we look at those points in the relationship, and that's important. I'm going to talk about this a lot. Your affidavit, which is your statement about your relationship and about the abuse, and every single statement that we submit talks about this turning point in the relationship. So these are the things we look out for because they're very common. So what is VAWA? If you are just joining us, at the very beginning I said the VAWA stands for Violence Against Women's Act. It is a piece of federal legislation that covers all different aspects of domestic violence. Yes, Irene, it is a very important topic. Today we're going to focus just on the immigration aspect of VAWA. And VAWA applies to men and women, even though it has the word woman. You don't have to be a woman to apply for a green card based on being an abused spouse. It also applies equally to different sex and same-sex relationships. And we've done filings for men, we've done filings for same-sex couples, and we've been successful in all of those. So what VAWA in the immigration context allows is for you, if you're a spouse or a child of a U.S. citizen or permanent resident, or a parent of a U.S. citizen, you can self-petition to get a green card. And the reason is that this legislation came into being in the first place is that you should not have to remain in a relationship or in a living situation with somebody who's abusing you. Nobody should have to deal with it. So if you're depending on someone to get a green card and they're being abusive, you're not going to leave the relationship if that means you're never going to get your green card now. So what this does is allows you to do it on your own without the other person. You can also do it if you're already divorced, although you have to file within 2 years of getting divorced. There's no limit on the number of people each year who can get a green card from VAWA, which is nice. There are other family preference categories that there are limits. You can apply for the green card at the same time you apply for VAWA if your relative, your abuser is a U.S. citizen. In some circumstances, if it's a permanent resident, and that has to do with the availability of visa numbers. But applying for VAWA is not applying for a green card. If you started the marriage petition process with your spouse, you filed something called a Form I-130 Petition for Alien Relative. That is going to be, the VAWA is going to take the place of the Form I-130. So it's essentially it's a visa petition. So you don't get a green card because your VAWA is approved. You can file for the green card at the same time in the circumstances I just described. But VAWA, getting an approved VAWA petition gives you the right, or gives you the eligibility for a green card. There's other eligibility factors, and we'll get to those in a little. And if you have questions about any of that, please feel free to ask. You also, if you get an approved VAWA, you get a work permit. That will be valid for a year and can be renewed. You also get a work permit when you apply for your green card. So you can get essentially up to 2 that are valid at the same time in some circumstances. But you can only use one. You are also not subject to certain grounds of inadmissibility. And what that means is certain things that will bar a person who's getting a green card based on marriage from getting a green card will not bar you if you're actually applying for VAWA. One example is someone who enters the country illegally. You have to prove that you entered the country legally to get a green card, even if it's with a visitor visa. But with VAWA, that's actually excused. So who can apply? Spouses and former spouses of U.S. citizens and permanent residents can apply. And as I said, if you're divorced, it has to be within 2 years of the divorce being final. Children of abusive U.S. citizens or permanent residents can apply before they turn age 25. So if a child is being abused by a parent or a step-parent who's a permanent resident or citizen, the child on their own right can apply. And if it's the parent who's the one being abused and the child is under 21 and not married, you can be a derivative on your parent's application, which means you don't even file your own application. Your parent files it, puts your name on there, and then you can file for a green card based on that. You can be, you normally are in the U.S., but you can be outside the U.S. when you file for VAWA if you ended up leaving the country because of the abuse. It's much more common to file for VAWA while you're still in the U.S. And your child, if you do have a child on your application, they do not have to live in the U.S. They could have lived outside the country. But if a child files on their own right, they will have to prove they lived with the abuser. And then parents of U.S. citizens also can apply for VAWA. We're not going to talk too much about that. It is rarer to see. We don't see it as often. But the general requirements are the same. But I will talk about children too, but I'm going to talk about it mostly in the context of spouses just because that's the most common. But the same exact things need to be proven. Even if you're a child applying, you still have to prove that the parent relationship, if your step parent's the abusive one, you have to prove that it's still, your parents have a real marriage. And as I said, it's not gender specific, so men and women can apply, and the requirement is that you have a valid marriage where you were married. So if you live in a state or a country that allows same-sex marriage, then you can apply for VAWA if you were a victim of abuse. And what about people who have a criminal history or a deportation order? In that case, there are certain things that will bar you from filing for VAWA or your green card, and depending on what the criminal history is. A prior deportation order itself will not, but you will have to deal with the deportation order. You will have to either have filed a waiver or have your case reopened. And in a case, you don't need to have a lawyer to file VAWA. You can do it on your own. If you have any criminal history or a prior deportation or removal order, it is highly recommended that you consult with an immigration attorney first. Because if you don't, and you have a crime that will bar you from getting VAWA and or your green card, you can end up putting yourself in a situation where you're gonna be deported, and you don't want to do that. So, what do you need to prove to get VAWA? What kind of evidence, what kind of documents do you need? VAWA petitions, they're a lot of work. They're not easy. And you want to give as much evidence as you possibly can, which is not always easy in these cases. And the reason they're not easy is because a lot of times people are fleeing the marital home. Or some evidence was destroyed, taken with somebody. A lot of times a spouse will assert control by not joining finances, not joining, putting you on the lease. So we'll get to that in a second, but the evidence is really what is the crux of your case for VAWA. You don't have an interview for a VAWA like you do in a marriage case. You might have a green card interview, but that will be after your VAWA is already approved. And when you go to your green card interview, they're not allowed to ask you about the marriage if you have an approved VAWA. So you got to put it all out on paper. So the first thing, of course, you have to prove is that you've been abused by a U.S. citizen or a permanent resident that you're related to. And how do you prove abuse? Well, there's not one specific way. You don't have to have a police report. It helps. You don't have to have an order of protection or a restraining order, of course. That helps. All of these things help. You don't have to have a medical record or report if you were physically abused. You don't have to have anything in particular. We always advise clients if they don't have, first of all, I should mention, if your life is in danger or you're at serious risk of physical injury, you should 100% call the police. And you should not be afraid to call the police if you're here illegally. A lot of people are, and that's understandable. And I can't speak for the entire country, but I know in New York, if you call the police, the police are not going to care that you're here illegally. They're going to do their job and protect you. So I want to make it clear, I'm not advocating not to go to the police. I'm saying if your life is in danger or serious risk of physical injury, 100% go to the police. There's no question. And if it's not that imminent, getting an order of protection is a very good way. You go to family court. You don't have to have your spouse or parent or child arrested, but you can get protection. So those things definitely help. In cases where we don't have physical abuse or threats of physical abuse, and it's more of the psychological, or it's called extreme cruelty, in those cases, I recommend, and actually I recommend for everybody, that they go see a therapist. And we get a letter from the doctor explaining the situation. And going through an abusive situation is extremely traumatic, especially when you have your immigration status on the line. So I recommend everybody do this when they come into my office, no matter what. There's an added bonus that we can take an evaluation from the doctor and back up some of the things that you're going to be saying to immigration. But it can be very helpful and necessary to help you get through a lot of what's going on. And we do help our clients find therapy. There's a lot of nonprofits out there that do no-cost or low-cost therapy that we're familiar with that have been really great help. So, and then if you have a physical injury for abuse, pictures also help. I often have clients give me pictures of it, and we're also going to be writing about it in our affidavit. As I mentioned earlier, your statement is going to be the most important piece of evidence that you submit. It's what I spend the most time on with clients, and very detailed account of your relationship and the abuse. And it's often so important because some of this, you might have been afraid to go to the police. You might have been afraid to go to the courts. You might not have gone to the doctor because you were afraid or didn't have insurance. So especially when you're missing pieces of evidence, you're going to explain all that in your statement. And unlike other types of immigration benefits, like applying based on your marriage with your spouse, certain evidence that you don't have, you can explain and it can be excused. So, for example, if you don't submit proof that your spouse is a U.S. citizen, so their naturalization certificate or their passport picture page, or if they're born in the U.S., their birth certificate, if you don't submit that with a marriage petition, your case is going to get denied before an interview. You'll be given a chance, most likely, but it's going to get denied. In a VAWA, you might not have it because you might not have had access to that, but you still have to prove it. So I've had plenty of clients come in and say, I don't have proof of my spouse's citizenship or my spouse's permanent residency. What do I do? Well, we take every effort that we could possibly do to get that proof. But if we can't, then we explain in our statement, here's what we did. I don't have it, but here's how I know my spouse was born in the U.S. And it could be that you had conversations, you talk to your spouse's parents about the hospital he or she was born in. There's all sorts of ways. I've been able to, some states let the spouse get the other spouse's birth certificate, so I've gotten birth certificates for clients before. And if your spouse wasn't born in the U.S. and went through the immigration system, the immigration should be able to find him or her. But there's definitely scenarios where we don't have that proof whatsoever, and we have to explain it, and we've been successful that way as long as we explain it in detail. So the next thing, you have to prove the relationship. As Stephanie, you have to prove that you're married, or that if you're the child, that the citizen or permanent resident is married to your parent. And you do this with marriage certificates. You also have to do, if you've ever been married before, the other person's been married before, you have to do divorce certificates. And then you have to prove a good faith marriage. So what does that mean? It means you didn't just get married to get a green card. That when you got married, you had the intention of sharing your life together. And it should be both financially and socially. And when clients come into us, the first thing we do when we get started is we give them a questionnaire and we give them an exhibit list. And on this exhibit list is a list of evidence that can prove a marriage is real. There's not one right way to look at a marriage. So you can't just write down on a piece of paper, this is what a person should have and that's it. Everyone is different. Everyone has a different situation. A lot of people have joint bank accounts, but some people don't. Some people have terrible credit and can't get a joint credit card. So there's no right way, but what you want to do is you want to get as much evidence as possible. And this is true, if you're applying with your spouse or if you're self-petitioning because you've been abused. As I said, we run into a lot of evidence issues. So what do you do if you fled your marital home? You didn't take the photos with you. You didn't take utility bills. You didn't take the greeting cards you guys gave each other on your birthday. You don't have anything. That is more common than not when you're filing for VAWA. So what we do in this situation is, again, we go to our affidavit. We go to our statement. We explain, here's what we had together. Here's why I don't have it now. We also see a lot of times where there aren't a lot of joint documents. Yeah, my spouse said that we'll open a joint bank account, but then he never went with me to the bank. Or he was supposed to put me on the Optimum online bill, but then refused to call. It's a way to assert control over the spouse. So a lot of times when we file VAWA, we see that there are a lot of false promises about joining finances that never happened, or there was just a flat-out refusal. Fortunately, that won't prevent you from having your case granted as long as you explain what your situation was and how you still shared a life together. You still shared a joint financial life. If you lived in the same place, somebody paid for rent, somebody paid for groceries, somebody cooked, somebody cleaned. So we explain all of that. The next thing you need is good moral character. And what that means is you're a good person. Basically, you have no criminal history or very little criminal history. If you have any criminal history or even any arrests, that's another thing that goes in your statement that we explain. If you go to church or temple or synagogue or any religion of your choosing, if you're a member or we get a letter from your place of worship. If you do volunteering, we will get proof of your volunteering. And then what we also usually do is supplement it with a couple of letters, 2 to 3 letters from family or friends talking about how you're a great person. And, it could say anything like, I've known, X for 20 years, and she's always helping, nice old ladies cross the street and carrying their groceries for them. She's a great person. Every time she comes over, she teaches my son Spanish. Whatever it is, we try to put something a little specific to show that they really know you and know that you're a good person. Next, you have to show residence with the abusive family member. This is most likely going to overlap the category of good faith marriage because the same things that you submit to show that you are living together are the same things that show that you have a real marriage: joint lease, utility bills. I can't even think of more off the top of my head right now, but we have a long list of that. But you get the point. And then that's basically all. Those are the basic categories that we have to show. So it's a lot of stuff. And as I said, there's always evidence issues that come about. But what's important, especially if you're missing a lot of evidence, it is highly recommended you have an attorney help you. it will not bar you from applying. And that's what's important. And we've been very successful with very little evidence, but we have to have a good reason. You have to explain it. And the more details you have, the more important, the better it is. And I always tell clients when they come in, the way we do these statements, I say, you're gonna end up finding that this is a really therapeutic tool for you to really write about everything that's happened in your relationship. You're gonna start at the beginning when you met your spouse, and then you're gonna go through the dating period and put in dates and specifics as much as possible. Why you wanted to marry this person, when things were good, what'd you guys do together? How'd you share your finances? When did things go south? When did things change? When did your spouse start acting different? What did you do? Why didn't you go to the police? And I tell them this is gonna take you a while. I want you to go home. I want you to write a draft, take your time. When you're dealing with traumatic situations, a lot of the times you can't remember things always right away. So it could take time for the whole story to come out. And then I tell the client, bring it back to me. I sit down with you. We go through it. I'll ask questions. I'll say, let's add some more information here, more details here. When did this happen? Or this contradicts this. And we make sure that your story is really solid. And it could take, I have clients that write it one time and it's great. That's rare. Most people, it takes, a few times for them to go back and fix it. And the reason we're so successful with these cases is because of the time that we take in explaining all of this. So I can't emphasize enough how important the statement is. What other issues are you going to have with applying? And if you are just joining us, I invite anybody who has questions, please don't be shy. You can ask a question on the live session, and if you want to ask anonymously, you can direct message me or email me, and I'll be happy to answer that as well. So as I mentioned earlier, a VAWA petition, a VAWA approval, is not a green card approval. It is the visa petition portion of getting a green card. It's what makes you eligible for a green card. So you might be eligible for VAWA, but it doesn't mean you're eligible for a green card. So there are certain inadmissibility grounds that apply to the green card that do not apply to a VAWA. Like, for example, certain criminal grounds that even if they're not, the crime doesn't prevent you from getting VAWA, or the good moral character portion, it might prevent you from getting the green card. So that's, again, I stress, not just criminal history, but any immigration violations. Before you apply for either, you consult an experienced immigration attorney. One thing that a lot of people don't know is that, and I did mention this earlier too, an entry without inspection, aka someone who enters the U.S. illegally, that person would not be eligible for a green card without a waiver based on marriage to a citizen or a permanent resident, but with a VAWA, they will not need a waiver, and that is a big difference. Other issues that can come up, we talked about divorce. If you're going to get divorced from your spouse, you certainly can, but you have to file for VAWA within 2 years of that divorce being final. Otherwise, you are just precluded from filing. Another thing that can happen is loss of immigration status by the abuser. It could be, you can lose your citizenship if you were naturalized. It's rare, but it can happen in a denaturalization process. More likely, if your abuser loses status, your abuser was a permanent resident. So if you're abused by a permanent resident, and let's say you got that person arrested, it doesn't even have to be you, but let's say you call the police because of domestic violence, your abuser was arrested, and the crime that they were convicted of caused them to lose their green card. You might be worried, now I can't get VAWA because now I'm not married or haven't been married to a permanent resident. Well, the good news is that you can still get VAWA. Just like with the divorce, you would have to file within 2 years of that person losing their status. I haven't seen that too often. I'm sure it certainly happens, but you don't have to worry about that, at least, because you don't need another reason to not call the police. You should always, again, call the police if you're in danger. What if it turns out that you're not really married? We've seen this many times, and what I mean by that is you didn't know that your spouse never divorced their prior spouse. And honestly, I've seen a lot more than you probably think I see this. Sometimes it's it's intentional, and sometimes it's not. Yes, it's called bigamy. Bigamy is a crime in this country, but it happens because if anyone who's ever gotten married, when you go to the clerk or city hall or whatever, they ask you if you've ever been married. If you say yes, have you ever been divorced? Yes. They don't have a system to check it, so people lie, unfortunately, and they marry somebody, and if you marry somebody when you're already married, it's not a valid marriage. Even if you've come from a country where that is valid. In the U.S., that is not valid. So when that happens, the good news is this. If you in good faith believed that your spouse was legally able to marry you, even though they were not, you can still apply for VAWA. Another issue can happen where the abuser ends up calling the police on you and gets an order of protection or a restraining order against you and turns it around. It could be in retaliation to something that you've done, like filing for an order of protection, or it could be on the offense. It could be the first step. We see this again a lot because a lot of times this is part of an abusive relationship that they're using, just like they threaten to call the police on you if you don't give them money or don't do what they say. They're doing it to control you, and they're doing it to blame you for things. So we actually can use that fact and for our benefit when we're explaining the situation. If you are in that situation, you do want to make sure a criminal case is handled properly, as well as a family court case, because you don't want to have a finding against you, especially if it's not true, that says that you abuse somebody, because that could affect your ability to get a green card. So you want to work closely with a lawyer. In family court and in criminal court, if you can't afford a lawyer, you can have one appointed. It's very common, actually, for us to represent somebody in the family court proceeding as well as their VAWA case, because they do go hand in hand a lot. And same on the criminal side as well, when the victim is the one who's actually arrested. Again, I want to remind everyone, if you have questions, don't be shy. I'm happy to answer. Otherwise, I'll keep going. So, what is the process to apply? What can you expect? How long is it going to take? What's it going to cost? These are everybody's favorite questions. I'll give you a nice little overview here. First, spoiler alert, I cannot tell you how long this thing is going to take. I wish I could. If I could tell you how long it's going to take, how long until you get your green card, I'd be a very rich woman, because I could see the future. USCIS, the United States Citizenship and Immigration Services, is a mystery. What they do and why they do things, it's always been it looks like I have an anonymous question. 1 second, let me take a look at the email. Give me 1 second, everybody. Being undocumented, is it possible to get an EAD, or that stands for Employment Authorization Document, or a work permit, while waiting for the VAWA approval? Yes, it is possible. Great question. It is possible if you are able to concurrently file for your green card. So if you're a spouse of a U.S. citizen, a child of a U.S. citizen, a parent of a U.S. citizen, or you're a spouse right now if you're a spouse of a permanent resident, because the visa numbers are available. So if you're allowed to file both applications together, you also get to file your work permit and travel document at the same time. And you can renew those. You can renew the work permit if you're still waiting more than a year for your green card, which you're probably going to be waiting more than a year. And then you also will get a work permit if you check the box that you're living in the U.S. and you want a work permit when your VAWA is approved as well. I've had clients file for a renewal for their work permit, and then while they're waiting for their renewal to be approved, their VAWA gets approved, and they automatically get a work permit, but in the VAWA category. So, good question. Again, I am checking my email, so if you want to ask me a question anonymously, please feel free to ask. Getting back to the process, as I said, I wish I could tell you how long it's going to take. On average, in a non-COVID world, they take the VAWA part takes about a year. So even though you file it all together, the green card and the VAWA, you have two different offices who are going to make a decision. There's one office in the entire country that decides VAWA petitions, and that's in Vermont. The Vermont Service Center handles all VAWAs. And after they decide the VAWA, if they approve it, they then transfer it to your local office. And that's where, if you're going to have an interview, that's where your interview is going to be. In the past, VAWA petitioners didn't get interviews too often. It's more common now under this current administration. If you have any type of criminal history or any serious immigration violations, you can expect an interview. But again, at that interview, they cannot ask you about your marriage. They cannot ask you about the abuse. They can only ask you about your eligibility for a green card. So you don't have to relive all that again, which is a very good thing. So if you file everything all together, the way the process works, you file everything. About 2 to 3 weeks later, you get a receipt notice. And then a week or two later, you go and do fingerprints. And then you get what's called a prima facie determination, which is the first step in them accepting your application. Basically, they go through a checklist, and every category I mentioned earlier, proof of relationship to a U.S. citizen or permanent resident, proof of their immigration status, good faith marriage, abuse, good moral character, all of those things. If you have one piece of evidence for each of those things, they check it off. And then they send you this prima facie determination, and that does entitle you to some public benefits. It also is helpful to prevent authorities from placing you in removal proceedings. That kind of has them back off, and it's valid for the whole time that your VAWA petition is pending. So if you're someone who couldn't concurrently file for your adjustment or your green card, having this prima facie determination is some security. About 3 to 4 months after your filing, if you were able to file concurrently, you're going to get a work permit and a travel document, which will allow you to work legally and travel abroad and return to the U.S. For a year, and it can be renewed if you're still waiting after a year. One word of note on the travel document: just because you have an approved travel document doesn't mean you should travel. If, for example, we have clients who entered the country with someone else's visa, that's called fraud and misrepresentation. And although you might be able to get VAWA and a green card without a waiver that way still, if you travel abroad and you try to return and they see that, they're going to detain you or just not let you in the country. So just because immigration approves your travel document does not mean they're going to let you back in the country. If you have any doubt about coming back into the country, you should talk to an immigration lawyer. Then about a year, sometimes more, sometimes less, you hopefully should get a VAWA approval. Now, if you do everything the right way, and when we file these petitions for clients, we do not submit it unless we have all the evidence we can possibly have, then you're not going to get a request for evidence. You're not going to have delays. It's just going to be after you get your work permit travel document, you get your VAWA approval. And like I said, once your VAWA is approved, you're going to get a work permit if you check the box that you want one. And you get other public benefits are available to you at that time. You also get something called deferred action for 15 months, and which can be renewed. And what that means is that there's no risk you're going to be placed in deportation proceedings. Now that can be removed if you committed a crime or something, but basically the government is saying, okay, we're not, for 15 months, we're not going to try to deport you. And it gives you a chance to apply for a green card if you haven't, or wait for your green card without being concerned about that. And then once your VAWA is approved, it could take anywhere from a few months to a year or so to either have your green card interview or to get your approval. And obviously that's the ultimate goal here, is to get your approval. So from start to finish, from the day one filing to when you get the actual green card with the VAWA process, you gotta figure 2 years. But the good news is, after a few months, you should be able to work, and if you needed to travel abroad, you could do so. If you receive VAWA and you're married, and it was based on your marriage to a U.S. citizen, then another good thing is that after only 3 years of being a permanent resident instead of 5, you can apply for naturalization. So that's a big thing for people too. It basically, it's the same as if you were still married and living with the person. That's the only time other time you can apply for citizenship within 3 years. So what if your application is denied? If your VAWA petition is denied, you have 2 options. 1, you can appeal it. And 2, as long as you're still eligible, meaning like if you were divorced, it's still less than 2 years, you can refile. I've had clients come to us. We were like either the 4th attorney or the 4th filing. The first 3 were just no evidence was given, and then we've gotten those approved. So the reason you do an appeal versus refiling, it's going to depend on your circumstances, and the only way for me to advise on that is to review your case. But in terms of cost, there are differences in terms of, are you going to lose your ability to work at the time? You know, there's all sorts of things to take into consideration, but essentially you can just refile. Even if you appeal and lose, you can refile. So that's good news as well, because sometimes people try to do it themselves the first time, or they use what's called the notario, which is not a lawyer or a paralegal, to do it, and it's not done right. But you're not going to lose your chance if you did that. You might have lost some money, but that's about it. Again, if you have questions, please feel free to ask. So we talked about VAWA, and so this would be somebody who does not have permanent resident status in the U.S. But what if you already got your green card and your spouse is being abusive? What's going to happen? So if you get your green card based on marriage, or your parent does, and on the day of the green card interview, you've been married for less than 2 years, then you're going to get what's called a conditional green card. A conditional green card is valid for 2 years. Within the 90 days before your 2-year green card expires, you and your spouse are required to file a joint petition to remove what's called remove the conditions on your residency. And you have to prove you're still married and you're still living together. And if it gets approved, you then get your 10-year green card. And usually by the time it's called a Form I-751, the I-751s are approved, you're eligible to, you have the 3 years you're eligible to apply for naturalization. So what happens if you get your 2-year green card and then your marriage you start that problem that your spouse starts to be abusive or the parent starts to be abusive? Well, the good news is you do not have to stay with somebody who's abusing you just to keep your green card. In this situation, you would file what's called an I-751 waiver of the joint filing requirement. It's the same form. You're still going to have to prove that your marriage was real from the beginning, but you don't need your spouse's signature. You don't need to stay living with them. You can divorce them. In fact, divorce is a separate waiver ground. If you entered into a marriage in good faith, but it just didn't work out and you got divorced, that works. In fact, a lot of times when we're dealing with abused spouses, they're eligible for both grounds, but a divorce can take time to be final. You can't apply for the divorce ground without a final divorce. Even though you started it, it doesn't matter. So if you've been abused, we file it based on the abuse. Once the divorce is final, we can switch grounds. It's just a little easier because you have to still prove you had a real marriage, but you don't have to then prove abuse. You just submit the divorce. So when you do an abuse waiver, the evidence is very similar to what we do with the VAWA in terms of the abuse. Same evidence issues can occur. Hopefully, you've been with the person a little longer and there's a little more evidence, but that's not always the case. So the statements are always super important. You still have to prove the good faith marriage. So you got to put in all that joint finances, joint taxes, joint bank accounts, joint cell phone plans, photos of you with your spouse or a parent. So in that sense, it's very similar to the VAWA. The good moral character, we still want to show you're a good person, but that's not a specific requirement of the abuse waiver. If you fail to file within the 90 days before your 2-year green card expired, I like that hashtag, Jessica Shapiro, no relation. What was I saying? Oh yeah, if you miss the filing deadline, you still need to submit that Form I-751. But you're going to have to give a good reason. And sometimes in abusive relationships, you're not able to file it. And that's okay. We just have, again, that's what we explain in the statement. And, the scary part is, though, with these I-751s, with these 2-year green cards, is when you fail to file, it's very good chance you're going to be put in removal proceedings. Or if your joint I-751 gets denied, you're going to be put in removal proceedings. The good news is you get another chance you get a chance to submit a waiver of the joint filing requirement, or if you did that already and that was denied, you get a chance to have it reviewed by the immigration judge. And if the immigration judge approves it, or USCIS approves your second filing, then your removal proceedings are terminated. So that's the good news. If not, oh, I got a question here. Hold on, guys. Oh, this is not a question. This is just a very nice comment from Tanya. Thank you, Tanya. So if you do have to go to immigration court and have the immigration judge review your case, essentially it's like it's a trial. So I would be with you instead of the immigration officer asking you questions. I would be the one asking you questions, and we would submit the evidence to the judge to show that you had a real marriage and that either you were divorced or that you were abused, whatever the case may be. In removal proceedings, another possibility. So there's something called VAWA, cancellation of removal. And this was going to be for someone who doesn't have a green card. This is for someone who's been placed into removal, aka deportation proceedings. And this also can apply to spouses and children. And this is someone who who's been in the U.S. for at least 3 years, has good moral character, has been abused, by a U.S. citizen or permanent resident spouse or parent. You have to also prove that you're not subject to a lot of the grounds of inadmissibility. And then the biggest difference between VAWA cancellation, besides the physical presence requirement, and regular VAWA is you have to prove that that your removal or deportation from the U.S. will cause an extreme hardship to yourself. And what an extreme hardship is, it means something that's more than the average person. So how do you prove that? It's going to depend on the scenario. I can just give a quick example. Cancellation removal cases, a lot of times you have, let's say you have a child, even if your child's not a citizen or a resident. In a VAWA, they don't have to be. Let's say you have a child who's disabled. And if you go home, they're not going to get the medical attention they need, or the education that they can get here, or they're going to be discriminated against. That's the type of thing that you could show an extreme hardship. So those are the basic immigration options for abused spouses and children of U.S. citizens and permanent residents. I covered a lot here. To quickly review some of it, we first spoke about what abuse is. We went over spotting red flags in a relationship. It's not just physical abuse. It could be emotional and psychological abuse. I explained what VAWA is, the Violence Against Women's Act, and how you apply for it, the type of evidence that you're going to need, and what kind of evidentiary issues that you're going to run into that are common with these types of claims because of the precarious situation that you're going to be in when you're in an abusive relationship. So you flee the marital home, you take nothing with you. How are you going to show that you have a real relationship? And how are you going to show that you're abused if you're too afraid to call the cops? So we talked about all of that, and we talked about how important it is that you have a really detailed statement describing not just your relationship, but the abuse, and then any reason that you don't have certain evidence, because VAWA, unlike almost anything else that you apply for with immigration, you're going to be excused for not having certain required evidence. You have to explain it. We talked about who can apply, the different categories, the process, how long it's going to take. As I said, if I could tell you that, I'd be a rich woman. But essentially that you get what to expect with the receipt notice, biometrics, interview, etc. We talked about getting your naturalization in 3 years if you get your VAWA approved. We talked about VAWA cancellation of removal. That's when you're in removal proceedings and you don't have a green card. We also talked about removal proceedings if you had your 2-year green card and your joint petition got denied or your waiver got denied, and how you do that. So, as I said, we covered a lot of ground here today. I hope that this has been helpful to you. If you have any questions, unlike our last time, everybody was a little quiet today. I am always happy to talk to you and try to get you help for any of these things. I will post some organizations that can provide help when we're done with this. On our website, we have some up already. You can always reach out to me, and I'm happy to help. But, you know, the most important thing that I really want everybody to take away here is that you need to protect yourself. If you're in any danger, go to the police. Do not be afraid. And know that you don't have to stay with someone who's abusing you just because you need a green card. You shouldn't. You should never do that. And there is a clear path to get a green card, fortunately. And if you put in the evidence and you take the time to do it the right way, you can certainly be successful in doing it. So I hope everybody here found this useful. We will be back in a couple of weeks. I'm not sure of the date yet, but we'll be talking about family-based petitions, marriage-based green cards. And again, please don't hesitate to reach out. And thank you all for joining me today, and have a great night.